So it's 61, subsection 1 of the National Cohesion and Integration Act number 12 of 2008, and the particulars as set out in the charge sheet are that on the 19th of February 2020 at 21:00 hours at JK Live Citizen News TV channel in Nairobi, within Nairobi County, uttered words to wit that Maasai issues will be articulated by Maasais, not Manje, who can be able to get an audience in Mount Kenya, words that were intended to incite feelings of discrimination against non-Maasai communities living in Narok County based on their ethnicity. The accused person, through his advocates on record, filed a notice of motion objecting to the plea taking on 3 major grounds, and the grounds are that the Honorable Court be pleased to dismiss the charge sheet dated the 2nd of June 2020 for failure and or deficiency to contain the statement of a specific offense or offenses with which the accused person is charged, together with such particulars as may be necessary for giving reasonable information as to the nature of the offense charged, and B, that the Honorable Court be pleased to dismiss the charge sheet dated the 2nd of June 2020 for purporting to gag the applicant from discharging and executing his constitutional mandate in terms of Article 33 of the Constitution of Kenya 2020. And C, that the court forthwith refers the matter to conciliation in terms of the mandatory provisions of Section 60 of the National Cohesion and Integration Act number 12 of 2008. The application is further supported by the supporting affidavit of the accused person dated the 3rd of June, and it was submitted by the advocate for the accused person that the particulars of the charge sheet were quite vague, and further that what is laid out in the charge sheet is not sufficiently accurate to disclose any offense. Advocate for the accused person went further to submit that the NCIC Act lays out the procedure under Section 65 and that the final consequences are only applicable to this Act. A reading of the preamble of the Act also discloses that the main aim of the Act is integration but not prosecution. Issues of commission being both the investigator and the complainant were also raised and canvassed by advocates for the suspect. In regard to Section 61 of the Act, it was admitted that the law provides that the first option available to the Commission is that of conciliation, as opposed to preferring charges against any person under investigations. ADR has also been used in the criminal justice system as a way of dispute resolution, as particulars that support the charge. What is required of the court at this stage is to look at the particulars and if they disclose any offense in a language that can be understood by the accused person. It went to submit further that on the issue of who ought to be charged, that under Article 157, sub-Article 10 of the Constitution, that the office of the DPP shall not require the consent or guidance on how to draft charge sheet and who to charge. It was further submitted that the application is premature as the defense is yet to be supplied with the evidence to be relied upon by the prosecution. There was also no evidence that the suspect was being gagged, and Article 27 provides that the rule of law shall apply equally among all citizens. And the application by the applicant and the submissions thereof, as well as the response by the prosecution, I find that the law relating to drafting of charge sheets is contained in Section 137 of the CPC, and this provides as follows, that the following provision shall apply to all charges and information, and notwithstanding any rule of law or practice, a charge or information shall, subject to this code, not be open to objection in respect of its form or contents if it is framed in accordance with this code. A1, that account or charge or information shall commence with a statement of the offense charge, called the statement of the offense, and 2, the statement of the offense shall describe the offense shortly in ordinary language, avoiding as far as possible the use of technical and without necessarily stating all the essential elements of the offense, and if the offense charge is created by enactment, shall contain a reference to the section of the enactment creating the offense. And 3, after the statement of the offense, particulars of the offense shall be set out in ordinary language in which the use of technical terms shall not be used, provided where any rule of law act limits the particulars of an offense which is required to be given in a charge of information, nothing in this paragraph shall require more particulars to be given than those so required. The defense relied in the case of Londa Kipkemoy versus Republic. And that case, the learned judge quoted the case of B&D versus the Republic, that is reported in 2017 EKRR, where Honorable Justice Goge laid out the test as followed, that the law is very clear in regard to what is required of the prosecution in drafting the charge. That is to describe the offense shortly without necessarily stating all the essential elements of the offense. Though defense was quick in stating that the charge sheet is vague and lacks particularity, I do find that the charge sheet need not contain all the elements at this stage. I have perused the supporting affidavit of the applicant herein, and more specifically paragraph 9, and with utmost respect, I do find that the issues raised therein are evidentiary in nature, and in short, I find these are issues that the prosecution will be expected to canvass during trial. On the issue of whether a charge, on the issues that the court is to determine on whether a charge is defective, I find that in short the court will consider, or from the case law above, is that the court is called upon to consider if a charge is, according to the charge, it is known in law, and 2, if the court has jurisdiction to try this case, and 3, that the charge, if the charge lacks necessary particulars to allow the accused person to properly prepare his defense. From the above, I do find it is not disputed that this honorable court has jurisdiction to hear this case. And on the issue whether the charge is known in law, I find that the charge has been brought under Section 61, subsection 1 of the National Cohesion and Integration Act, number 12 of 2008, and the section provides that for the charge of ethnic contempt. As regards the particulars of the charge sheet, I find that Section 137 has clearly said that the offense should shortly be described in ordinary language, avoiding as far as possible the use of technical terms and without necessarily stating all the elements of the offense. On the ground that raised by the defense that the charge sheet be dismissed for purporting to guard the applicant from discharging his constitutional mandate under Article 33 and 96 of the Constitution of Kenya, again, I do find that these are issues that can only be dealt with during the main hearing of this case. It was admitted that there was selective charging of the case before court. Professor Wajakwa submitted that the radio station that aired the interview and all those involved ought to have been charged alongside the accused person. The Constitution is quite clear on the powers of the office of the DPP, and it is clear that the office of the DPP is independent and cannot be directed on who to charge and at what stage to charge any accused person. On the issue of conciliation, it was omitted Section 61(2) provides that the Commission shall make all reasonable endeavors to conciliate the matter. However, the Act only makes reference to the Commission after investigation, whence reasonable endeavors shall be made to conciliate. The Act imposes this duty on the Commission and not on the office of the DPP or the court. The law does not provide that failure to pursue conciliation is a bar to prosecution by the office of the DPP. In any case, conciliation is a process which and will largely depend on the circumstances of each case. To this extent, I find the objection by the defense on this ground also fails. Nothing stops the Commission nor the accused person from pursuing a DR or conciliation at whatever stage during trial. In the upshot, I find that the objection by the defense is premature and lacks merit, the same is dismissed, and the accused person is hereby called upon to plead to the charges as drawn.